Hi friends, how are you all? So today we are going to discuss about the landmarking cases on the preamble. So in our previous sessions we have completed a detailed explanation about the preamble. Each and every part of the preamble has been discussed. In altogether we have discussed in different parts like nearly I think 6 parts have been completed to explain the whole content of the preamble. So studying about the preamble and about the case laws are equally important. So let us see what are the case laws that are related to the preamble. Before that, let me introduce myself. I am Dr. Sashi Prabha, who is presenting you this particular topic. Now moving on, what are the important facts? Before going directly into the case laws, I just want to give some of the important facts which you may know and which are very important for your examination point of view. The first one is, which country first adopted preamble? We are saying that preamble is there and preamble is important for an Indian constitution, but which country first adopted preamble? From where we got this concept of preamble? So the answer for this is America. America was the first country that adopted preamble for their written constitution, and after that many other countries like India has adopted this practice of adopting the preamble. Right. Now moving on to the next point here. Who introduced preamble? So the preamble that we are following today was introduced by whom? Who introduced this preamble? And the person behind this was Jawaharlal Nehru ji. Constitution is based on the objective resolution. Jawaharlal Nehru ji, he proposed the objectives resolution. Objectives resolution. I'm just giving you the short form. So this objective resolution was introduced by Jawaharlal Nehru ji on 13th December in 1946. In 1946, 13th December 1946, he he moved the draft of objective resolution, and that was accepted by the Constituent Assembly. So that's the reason why we got the preamble. So preamble is been, how we got the preamble? We got the preamble from objectives resolution. And who passed this? Nehru ji passed this. On which date he moved this? 13th December 1946. Right. So this preamble is referred to the introduction or the preface of the constitution. It contains the summary of the constitution. Simply saying, the preamble contains the summary of the constitution. Next we'll see what is according to some of the eminent people, what is the opinion to them for this preamble, means how important the preamble is for them. So for example, if you take the N.A. Falkewala, according to him, the preamble is an identity card of the constitution and it is an introduction to the statute. Right, so preamble is an identity card of the constitution. Who said this? Palkewala. Similarly, if you take Bhargavji, that is Thakurdas Bhargavji, the preamble has been called as the soul of the constitution by Thakur Bhargavji. So what he called? Preamble as a soul of the constitution. And according to K.M. Munshi ji, the preamble has been called as the political horoscope of the Indian constitution. Right. So tomorrow you can get a question like, who called the preamble as a political horoscope of the Indian constitution? It was K.M. Munshi ji. So in this way, you have to know about different eminent people's opinion regarding the preamble. So you can get a question related to this. And with these words, we can understand the importance of preamble also. How important the preamble is. Moving on, so let's go into the case laws related to the preamble, the today's topic. The first case law here is the Beruberi Union case law. Just I am listing out all the case laws first and then we will go into the details of each of the case law. The second case law is the Goleknath versus the state of Punjab case law, and the third one is the Keshavananda Bharati versus the state of Kerala, and the fourth one is the LIC of India. All these case laws, it gives us the answer for a single question, that is whether the preamble is a part of the constitution or not. Should we consider preamble as a part of the constitution or not? In order to answer this question, these case laws are very important. Let's move on to the first case law, that is the Beruberi case. I'm not going into the depth of each of the cases. I'm just giving you what is the case and how it is related to the preamble. But later on, I'll make a separate video where I will explain you about each of the case law in depth, what was the case, everything, which is very important for your mains examination. But for now, I'm just giving you the outlines of the case and how it is related to the preamble. Now, moving on to this Beruberi case. This Beruberi case took place in 1960s on 14th March 1960. If you go into the details of the case, the Beruberi case was the presidential reference case. That is, it comes under the Article 143 Clause 1 of the Indian Constitution. So what is this Article 143 Clause 1 here? That is important. You have to know about this. So according to this Article 143 Clause 1, if the President is having any doubt, the power of the President to consult the Supreme Court, he can consult the Supreme Court. He can take the opinion of the Supreme Court if at any time it appears to the President that the question of the law or facts has arisen, then out of the public interest, public importance, to obtain the opinion of the Supreme Court. That is called the Article 143. So this case is related to the presidential references case, and this comes under the example of the Article 143. This is again one of the important bit. So can you give an example for which of the following cases will come under the Article 143? Beruberi case will come under the Article 143. So what is Article 143? The President taking the opinion of the Supreme Court for the public importance. Right. So now moving on to the details of this case. The Beruberi case, this has took place because of the Indo-Pak agreement. Okay, this is related to the Indo-Pak agreement, exchange of the enclaves, and this has been handed over by the bench of the 7 judges, and the 7 judges headed by the B.P. Sinhaji. The 7 judges were headed by the B.P. Sinhaji, and the Chief Justice for this is Gajendra Gadkarji. Clear? What is this Beruberi case? This is, I'm repeating once again, this is related to the Indo-Pak agreement. Okay, and this is related to the handing over the Indian place Beruberi to the Pakistan at that time. So related to this, a case was filed by the President in the Supreme Court, and this was handed over by the 7 judges, bench of 7 judges, and the Chief Justice for this was the Gajendra Gadkarji. Clear? These were the details of the Beruberi case. Now moving on to the judgment. What was the judgment related to the Beruberi case? I am going to the final judgment. The Supreme Court in the Beruberi case held that, the first point here, this preamble is not a part of the Constitution. What the Supreme Court said, preamble is not a part of the Constitution. Because of this, the preamble has no substantive purpose. Okay, it is not having any substantive powers because it is not a part of the Constitution. This was the first judgment given by the Supreme Court. So coming to the second point of the judgment given by the Supreme Court is, what it said is, yes, the preamble can be used as a guiding principle if a term in any article of the Constitution is ambiguous or having more than one meaning. If you want to know the meaning or the principle of any of the article, any of the term in the Constitution, then as a dictionary, as a guiding principle, you can refer the preamble. But preamble is not a part of the Constitution. This was the judgment given in the Beruberi case in 1960. So we completed the first case law. Now moving on, so since we completed the first case law, the second one is the Golaknath versus the state of Punjab case law. So what is this case law? This took place in 1967 after 7 years of the Beruberi case on 27th February. Right. So this is having a bench of 11 judges. It was decided by bench of 11 judges with Chief Justice as Muhammad Hidayatullah ji. In this case, let me tell you the facts, interesting facts about this case, means a small introduction about this Golaknath case. In this case, two brothers, that is Henry and William Golaknath, they were the two brothers. We write for you, Henry and William. These were the two brothers belonging to the Golaknath case, and they are owning the 500 acres of land. Both the brothers are having 500 acres of the land. But the Land Tenure Act, which was passed by the Punjab state in 1953, Punjab state has passed a Land Tenure Act in 1953. So, according to this Land Tenure Act, this much land should not be owned by anyone. Okay, this will not allow them to keep this much of land. So according to this act of Land Tenure Act, they are supposed to keep only 30 acres each, and the remaining will be handed over to the government. Then these two brothers have approached or challenged this Land Tenure Act in the court. This was the story behind this. Right. What is the story behind this? Two brothers, Henry and William, they are having 500 acres of land. So the government is not allowing them to keep this much of land according to the Land Tenure Act. Which state passed the Land Tenure Act? Punjab state. In which year? 1953. So what the government said at that time, you can keep 30 acres of land for each of the brother, and remaining will be shall be taken by the government. This was the case, and challenging this, they have approached the Supreme Court. It was argued that what they said is, what these two brothers, Golaknath brothers, said is, citizens have a fundamental right to property under the Article 19 of the Constitution. Now we are not having this article right to property, but at that time we have the right to property as a fundamental right under the Article 19. So why can't we keep this land? Why the government is taking our land? This was the case filed by Golaknath brothers. So the family filed a petition under Article 32 challenging the 1953 Punjab Act on the grounds that it deemed them their constitution rights to acquire and property and practice any profession. So on what basis they filed a case? They basis upon the Article 32, basing upon the Article 19, and basing upon the Article 14, they filed the case. Clear, guys? So they filed the case based upon these articles, Article 32, 14 and 19. So now let's move into the judgment. What was the judgment? The judgment that was given is, preamble is the heart and soul of the Constitution. So it is eternal and unalterable. What they said? Preamble is the heart and soul of the Constitution. It is eternal and unalterable, means what they said in the Beruberi case, that has been changed in this Golaknath case. They altered the judgment of the Beruberi case in the Golaknath case. But the clear-cut definition for the preamble, the clear-cut reference for the preamble with the Constitution, we get from the Keshavanand Bharati case, not from the Golaknath case. In the Golaknath case, nowhere they said that the preamble is a part of the Constitution. They just said that preamble is important. Preamble is the heart and soul of the Constitution. That's all they said. Okay, but in Keshavananda Bharati case, the next case is the Keshavananda Bharati case. In this case has created a history. Okay. In this case, which took place in 1973, 24th April, For a first time, a bench of 13 judges assembled. Okay, and all the 13 judges passed a recording opinion and 11 separate opinions. The 13 judges passed 11 separate opinions. Okay, and finally they came to a single opinion, and the chief justice for this was the Sikriji. Sikriji was the chief justice here. So let's move to the Supreme Court judgment related to the Keshavananda Bharati case. The Supreme Court overturned its earlier decision and held that preamble is a part of the Constitution and can be amended under Article 368 of the Constitution. So whatever you have studied in the Golaknath case or the Beruberi case, that was altered here. Supreme Court, what they said, preamble is a part of the Constitution and it can be amended under the Article 368 of the Constitution. So tomorrow if you get a question like, according to the Keshavananda Bharati case, preamble is a part of the Constitution and not. Yes, preamble is a part of the Constitution according to the Keshavananda Bharati case. Clear? And according to the Beruberi case, is the preamble a part of the Constitution? No, preamble is not a part of the Constitution. Clear? And according to the Golaknath case, can we alter the preamble? No, we cannot alter the preamble according to the Golaknath case. But according to the Keshavananda Bharati case, it has clearly said in the judgment that we can make amendments in the preamble according to the Article 368. Means it's a part of the Constitution. So you can use Article 368. What is Article 368? The amendment article. Right. So, along with these case laws, the last case law is the LIC of India case law. In this case law also, we got the same judgment just like the Keshavananda Bharati case. Okay, so let's see what is the opinion of the LIC of India case law. This took place in 1995, and here the Supreme Court held that the preamble is a part of the case law. So what are the two case laws which gives us that preamble is a part of the Indian Constitution? Keshavananda Bharati case law and the LIC case law. Right. So when this LIC case law took place, it took place in 1995. Clear? And they said that preamble contained the basic idea. So we know that the preamble contains the basic idea, objectives, philosophical postulates of the Indian Constitution, and they provide justification for the constitutional provision. So preamble is a part of the Indian Constitution, and this LIC of India case law was dealt by Chief Justice Ramaswamiji. So these Chief Justice, name of the Chief Justice are also important. So what is important in this particular session? What are the points that you are supposed to remember in this particular session or in this particular video is, first one, which case law is considering preamble as a part of the Constitution and which case laws are not considering preamble as a part of the Constitution. That you have to remember. You have to remember which case law took place in which year. Year is also important because you can find many of the question papers is asking about the Beruberi, in which year the Beruberi case law took place. Okay, it is 1960. It is one of the very important case laws. So the years are also important. Along with that, remembering about the Chief Justice. Muhammad Hidayatullah ji, Sikri ji, okay, Ramaswamy ji. So remembering the Chief Justice, remembering the judgment and which year it is. These are important in this particular session. Right. So these are the case laws related to the preamble. That's all for today's session, guys. So in the next session, I'll come up with a MCQs related to this case preamble. Okay, then after the MCQs, we will complete the topic and I'll come up with a new topic related to our syllabus. I'm not going away from the syllabus. From the syllabus only, I go according to the syllabus only. Okay, each of the parts according to the syllabus. Okay, so why I'm providing you the MCQs is it is very important for you to assess yourself how far you understood the topic after each of these sessions, and it is also helpful for you for the revision also. So thank you guys. Subscribe to this channel to get the upcoming notifications. Click the bell icon so that whenever I post a new video, you will get the notification related to this. Thank you guys. Take care. Bye bye.